Hello, my name is Regina DeMeo, and I'm a family law attorney in Maryland and DC. I've been practicing for over 20 years. And with me today is John Weaver, who is a colleague that has been practicing for over 30 years and was also a magistrate in Montgomery County Circuit Court. He's got tons of experience and recently released a book, The 7 Principles for a Just Divorce. Thanks so much for being here, John.
Thank you, Regina. I really appreciate this opportunity.
Yeah, absolutely. So I first have to tell you the book was great. I loved reading it. I think you did a great job of translating all of our legal jargon into, something that anyone could really comprehend. So that was fantastic.
Oh, thank you. Yeah, I want it to be practical and useful for clients, but there's actually some helpful stuff for attorneys in there, I believe, too.
No, absolutely. So one of the first things I want to ask you is, in addition to going through the justified reasons for wanting a divorce, you also emphasize the importance of having justified principles when you're going through the process. And so I thought maybe you could talk to people about why you think that's so important.
Yeah, well, one of the things that the book sort of, by analogy, I use just war principles. And in just war, there's the decision to go to war and the justness of that and the way you pursue or prosecute a war. So by analogy, I believe those same kind of principles apply to, divorce. And so, for example, in going to war, you have to have the principles of, just cause, and in my case, that deals with the grounds for divorce. And then you want to look at the just intention, what are your motives in going to war? What are your motives in going through divorce? Is it in a war, is it a land grab? Is it a matter of greed or vengeance in divorce or war kind of thing? And then, one difference in principle just war, just divorce is in just war, you've got to have a legitimate authority, generally a government who declares a war. And the just divorce, we've got a mix of the state and the church and individuals. And so, I would see like the government playing a role of an orderly process and some fair standards and goals. And then, the individual basically being to make the decision. And then, and then you also in part of the decision, you're limited, reasonable, realistic objectives and going to war. But when we get into the prosecution with the principles, what you're dealing with there is, what are the means? You want it to be proportionate to what the wrong is, proportionate to the issues at hand. And so in the reasonable means and justified, I look at the various aspects of negotiation and alternative dispute resolution, whether it's mediation or collaborative divorce or, Christian conciliation or even arbitration, and then litigation. And so, it may be that you can resolve everything short of litigation. And so that should be a goal. If you're in litigation, you can still try alternative dispute resolution. But the idea is to come up with in war and divorce is a peaceful outcome, come to a just peace. And so the principles are important. But the one principle of just war that really struck me was this the last principle, and it's called the principle of discrimination or the principle of immunity of non-combatants. That's where we deal with, avoiding collateral damage. And to me, it just fit naturally into this whole concept of protecting children from harm and divorce, and especially in the responsibility of parents to try to keep their children out of high conflict, because they're not the the spoils of war or something, and or to be used as sort of pawns or soldiers in the war. And so you want to keep them in a demilitarized zone. And so I have discussed in the book some principles of protecting children from harm and what the courts do in their to protect children from harm and in their decision-making process on custody, and also, child support guidelines and financial aspects. So I think that those just principles of how you, apply in how you pursue it too.
Absolutely. And so you do a great job of breaking down the issues. I just want to focus on one particular issue because you really do go through how alimony is so unpredictable and just so complicated. So maybe you could share some thoughts on that.
Yeah, I think one of the major differences over the recent years has been this shift from a needs-focused alimony, where it's kind of focused on maintaining a certain standard for a spouse, and looking really at the needs of the spouse, to this whole concept of rehabilitative or short-term alimony. And so the emphasis has now become supporting someone while they're pursuing self-sufficiency and doing the most they can reasonably to become as, you know, self-supporting, self-sufficient as they can. And so long-term alimony, which would have been more, you know, prevalent, let's say, in the past, is now more exceptional or extraordinary circumstances, such as because of illness or age or, you know, some other things, a person can't really become self-supporting, or there's just such a financial disparity between the two that, you know, the court, like in Maryland, it would be, you know, if there's an unconscionable disparity in standard of living, which, you know, the courts look at the unconscionable disparity in income as leading that. But I think that there's that thing, plus states all have different theories for alimony and different forms of alimony that are inconsistent. And for example, the American Law Institute has come up with a concept of compensation for loss rather than relief of need. So a spouse would not get alimony because necessarily they have a need, but because they've suffered some loss during the marriage. It may be the loss in the standard of living, you know, the premarital standard of living in a you know, short-term marriage, for example. You know, somebody, they may look at trying to get them back to their premarital standard of living in a short marriage, or if it's a long marriage, then maintain a, you know, a healthier standard of living, like in the marriage. But there's a loss in standard of living they try to do. And then another loss that the American Law Institute principles deal with is a loss of earning capacity, that a parent who, you know, by choice of the family stays home and cares for children, and then this loss of earning capacity is going to persist after divorce. And that earning capacity can be, you know, you lose income growth or increase issues, benefits, retirement benefits, things like that. And so the ALI kind of looks at that. And the problem is there are no uniform standards, really. Some states have tried guidelines, where the American Academy of Matrimonial Lawyers has some guidelines that people have used. In Maryland, there's a set of guidelines that, you know, not by statute, but it's a private organization called the Kaufman Guidelines, that try to take into account the kind of factors there are in Maryland. And so, you know, courts can look at those, and to the extent they're consistent with the principles, but they can't be bound by them if they're not ones that are binding in that jurisdiction. But many states have guidelines that they use for, you know, the temporary support issues and all. But the problem is there's no uniformity in guidelines. There's inconsistency, unpredictability within the same courthouse, whether it's a circuit court in Montgomery County, or a difference between the circuit court in Montgomery County and Anne Arundel, or you know, on the Eastern Shore. It's just so different. And so it's the most difficult thing to advise clients about.
No, I agree. And so I kind of want to ask you also, after you talk about the issues, you talk to people about the importance of preparing for negotiations and preparing for mediation. So what led you to want to dedicate, because you dedicate a fair amount of time to that, and which I thought was great, but what led you to do that?
Yeah, well, it's interesting. A lot of times, you know, books or articles, they deal with just the mediation process, but one of the things that struck me when I was writing my book is I just read the sentence that was familiar to me before, you know, but it just struck me at this point, and that is that mediation is facilitated negotiation. And it just, a light bulb went off with me, and then I read like 18 books on negotiation then, and just took to come up with what I thought was going to be a paragraph in the book. But then I just decided that really understanding negotiation was important for clients, because attorneys generally don't lay it out for them. What is the negotiation process? What is, and that kind of thing. And even attorneys sometimes don't have a well-formed perspective on negotiation. So I thought that negotiation was really foundational for people who are maybe representing themselves. It's also foundational when you're represented by another, you're in mediation, or so I thought that was a key thing. And then in terms of preparation, one of the things that really struck me as that I try to impress on clients was this, to ask yourself the basic questions, what are my needs? How do I prioritize them? Those kind of things. And there's a book by Charles Craver, who I'm not sure if he still teaches at George Washington University Law School, but in his book, he had suggested prioritizing bargaining in 4 broad categories. The first one is essential items. And that would mean have your client include what they must obtain to satisfy what you would call fundamental interest and basic needs. And if those key terms aren't resolved to their satisfaction, then they prefer their non-settlement objectives. So the essential items will be first. The next category would be, important items. And those you'd really want to have them, you'd like to have them, but you give those up for the essential items, so then the prioritizing there. And then the third one is like desirable items, those with secondary value, be pleased to have, but you'd be willing to exchange them for essential or important things. And then the fourth one is indifferent. There are just some things that, you're perfectly willing to concede in order to get your other bargaining objectives. And so if clients can sort of prioritize those, then they can avoid trading away, an essential item to get something that they're really indifferent about. And it can help them to stay focused on needs and see areas of bargaining, because one thing I found in negotiations and mediation is that sometimes one person has a priority and the other it's different. Can I just tell one quick story?
Yeah.
Well, what happened, this isn't in the law group, but it has to do with the prioritizing and how people have different priorities. When my father died about 18 years ago, I was a personal representative, and I have 7 siblings. And I had to divide the personal property between them, 5 sisters, 2 brothers. And one of the things that happened is that I came up with this idea where I asked them each to give me an order of priority, what was the 10 most important things that they wanted to have in terms of the personal property. And what was really interesting is when I got it all back, like everybody pretty much got their number 1 priority, because they were different things, whether it was economic value or sentimental value that they had. But then there was one item that 7 people wanted, including me, and so, there wasn't really mediation. I had to just make a decision, but it was my 5 sisters who wanted it, and my brother, and I who wanted it, one of my brothers. And, and ultimately it was interesting because I shouldn't say, but I made a decision that would go to my brother, and then all 5 of my sisters were like, oh, okay, because it might have been a different result if one of them had gotten it, or if I had gotten them, but it's just the way it worked out. But what I'm just saying, though, is in negotiations, there are those items where we want things and the other person wants something different, and everybody can come out with some of those things. And then the other thing too is just with clients, you want them to try to understand the difference between what their position is on an item and what their really underlying motive or need is on something, because so often in negotiations, and it's partly because the attorneys don't prepare the clients, is the clients make a proposal and then they think they have to get all those things. That's their position, and they think that they're giving up on something if they don't, or they're upset about it. And so, so you want to be able to know that, and even from the outset in preparation to settlement objectives, to go through the most significant issues and not just do the thing I said about the essential, important, desirable, kind of thing, indifferent, but also to look at certain items and just see what would be a desirable outcome on that particular item, and then have that. And you have to also talk to your client about at what point would they rather have some alternative to a negotiated settlement and let the court decide, or some other option. And so you need to think that out ahead of time, because otherwise they might just keep giving away, and then all of a sudden they come to a decision which is a much worse outcome than they might have had otherwise. And clients need to know, that they prepare them for the flexibility in negotiations, but not rigidity, but to be flexible. But and then there's just one thing I would say, you mentioned you once in the mediation, I've also found as a mediator that the attorney's concept of negotiations are just wildly different and can affect the outcome. And one example, many years ago, I had a case where um, you know, one side made a proposal, and what I would say that they sort of dropped the anchor pretty high or something like that. But and the other side made a proposal, and then the first side, they didn't really move much, and the other side was just, the attorney was angry because he was like, he said, this is not fair, because in negotiations, you know, I make a proposal, you know, they make a proposal, I make a proposal, and then they meet me halfway. And that was his whole concept of negotiation. And I'm thinking, and I might have said it, or I might have just been thinking in my head, well, that depends on where your starting points are and everything else. But so I think that attorneys can really need to think through for themselves what are their concept of a negotiation is, and then prepare their client for the process and the back and forth.
No, I agree. When I'm mediating, I feel like the attorneys are very clear on what their clients' positions are, but they often have no idea what's the underlying motivation for the ask. And a lot of time is spent me figuring out from their clients, why is it that you are seeking this?
Right. Well, yeah. And I had a client once who was very upset. She had to have the 4th of July every year, but she wouldn't explain to me or anything. And then what happened was, when we eventually sat down, and she was crying, and she told me that her birthday was on, I think, July 3rd or something, and that, you know, her father wanted to go past that. He always would talk to her about the fireworks and the stars and things as being for her. And so for her, she associated the 4th of July and fireworks with her father and with that relationship and with her birthday, and something that was really special to her growing up. But nobody would have known that that was the reason that she had to have the child the 4th of July every year or something. So, you know, we were able to then figure it out and work it out.
Yeah. So you also talk a lot about reining in anger and this desire for vengeance, right? Which is definitely not easy, right? And I have to say that one story that you shared in your book was so funny, about the woman that came in and said, you know, the reason I'm here is because I want to see my husband hanging from your window, right?
Right.
So how do you help your clients steer away from wanting scorched earth?
Yeah, well, one of the things that I do is that I since I've been practicing almost 40 years and 6 years as a magistrate, that I sometimes draw on that experience as to, you hired me for my advice and for my experience and that kind of thing. And I also do a lot of testimony as an expert witness on attorney's fees. And so that I bring to bear sometimes with clients, in terms of just pointing out that attorney's fees deplete assets, they don't create new resources. And then I might tell them some horror stories about cases, not giving up any facts, but just the idea that litigating certain things, you know, 150, 250,000 in Montgomery County and that kind of thing. And I talk to clients about how, you know, some of the things they're angry about are just minor to the court in terms of, you know, just one of the 10 or 12 factors, and are unimportant, and that they, you know, that vindication is not what it's laid out to be. They're not going to get, the courts aren't there to vindicate or to be their personal sword of vengeance on the other side. And so I try to point those out. But then another thing I do is, sometimes when they're really angry, because, you know, as you know, we're seeing some really good, nice people, good people in their most awful moments of their life, where they let their hair down and it's just all out. And I've said sometimes, you know, okay, I'll be your lightning rod, you know, don't worry, you can vent for me, and I'm not getting out of the case because of that kind of thing. And then sometimes that diffuses their anger, and we can turn it to something more productive. And you know, I try to mention to them about, you know, the anger just turned inward, and depression, or coming out in a worst outbreak. And with some clients, frankly, it's actually a good thing they're showing some emotion, that they're showing some anger. So I do that. But I think with every client, angry or otherwise, I think that getting into some sort of counseling, having someone to talk to other than just friends or attorneys, a professional, because frankly, I don't know how anybody goes, even amicable divorce, I don't know how anybody goes through divorces without it impacting their functioning at work or at home or elsewhere. And I think that having somebody who can help them address those those issues, and do that. And as an attorney, I learned long ago, early on, I was fortunate in my career to learn about the concept of not taking on the client's emotion as an attorney. I had a situation once where, something happened between my client and the spouse and their child over the weekend, and my client was really, really upset and called me and stuff. And I remember I called the other attorney and I was like, blah, 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 your client did this, your client did that, kind of thing. And the other attorney, it was funny. He goes, John, wait hold on a minute. Just hold on a minute. He goes, John, I wasn't there. Were you there? and stuff. And then we had a good laugh. And then it just realized that really we can take what our client says, we can pass it on, we can communicate it, we can be advocates. But once you take on that emotion, like get into that kind of, it wasn't even a conflict with the other attorney, but just that kind of, not even advocacy, just totally taking on what your client's mindset and emotions, and it just doesn't help. It's hard enough negotiating in family law, and
No, I agree.
That.
So, if you have a client that is insisting on an approach that really doesn't conform to your, especially like your Christian values, right, and the way you think a case should proceed, what do you do in those situations?
Well, one of the things, and ethically, the rules applicable to us as attorneys, we as advisors and counselors can render advice that refers not only to the law, but also takes into account other considerations, whether it's economic or moral or social, political kind of things. And so that may be relevant to the situation. So I will do that sometimes. I mean, I'm not like I take the Bible and verses quote. I'm not saying that, but it's just that you can work around the edges and work toward it and try to talk to them about that. I try to dissuade them, point out the costs, both not just financial, but the emotional costs, social, legal costs, how what they're considering will just really backfire on them in court. And one thing that was very prominent for me is we talked about the avoiding collateral damage and not targeting the children, is just to don't use the children as pawns, and not so that when I do it. But then I try to let them know how to be perceived by the court, and that contacting the IRS or an employer about something, what's the end game? You want your spouse to lose employment, so either you need to provide more support, or they have less ability to provide you support, and so those kind of things. But sometimes it does get to the point where if a client is insistent on things, I mean, clients can decide whether they're going to accept a settlement proposal or not, and I'm totally, I'm kind of bound by that. But when it comes to other strategies and stuff, I think I have more influence on that. And if it gets to a point where it's an intractable conflict or impasse, then I would get out. And I've used this kind of sometimes as not in my stomach analogy. I mean, there are just some cases that, you see that envelope, you see the phone call message, you see the number, you just get a knot in your stomach. And so, I've sometimes had to do it. And it happens sometimes that the client realizes that at the same time that
Right.
we're not a good fit or whatever. So, but.
So this has been great. Do you have any more upcoming talks?
No, I've got some radio interviews that I'm kind of excited about. A magazine, Faith-Filled, Faith-Filled something, wants to do a feature on me with an interview in the upcoming issue, and then I have a radio interview with a show, a live one next week for 45 minutes, and I have a couple things that have been recorded that are being offered to radio stations. So, but I don't have any particular talks about the book right now, other than that.
Is it available on Amazon?
Yeah, it's available both in paperback and a Kindle ebook through Amazon.com, and I also made it available through the Kindle Unlimited. So if somebody has Kindle Unlimited, they can, I guess, read it for free as part of their thing. And but it's also available for purchase. I think just under $10 for Kindle and just under $25 for Amazon paperback.
That's great. So if people wanted to contact you for any further information, what's the best way to reach you?
I set up a website www.ajustdivorce.com. I was able to get that. I was actually able to get that A Just Divorce for Twitter and Instagram and Facebook. You know,
Okay,
but in that on that website page, there's a contact page which has both my law firm website and all my other social media contact information too.
great. This has been so much fun. Thanks for doing this today,
Oh,
John.
thank you, Regina. I think your podcast is just great, and I appreciate having a chance to be part of it. Thank you.
Absolutely. Well, stay tuned for next time and stay safe.